go back to that pre-dawn raid a little later on, sir. I just want to get an update on the inquest proceedings yesterday.
Yes.
So, what is the update there, sir?
Well, we started quite late. The CIDG was the one who requested the Office of the Prosecutor General that we start at 1. But they arrived at 2 with incomplete papers, so there was much delay. The special prosecution panel was there. The inquest panel was there promptly, led by Senior State Prosecutor J.P. Navera. And we started, and we no longer waived our right over the 36-hour period. As in fact, we had put on record our request to immediately set the respondents free because the 36-hour period provided for in Article 125 had been breached or had lapsed.
Ibig sabihin nun, Attorney Topacio, kasi prior to the inquest proceedings yesterday, you were already coming out on TV. Sinasabi nyo na parang yung rights po ng inyong kliyente, si Vice Mayor at si Reynaldo Jr. were violated. Sir, please correct me if I'm wrong because hindi po sila in-inquest within 36 hours, tama
yes,
ba? Okay.
that is true. Because the by our reckoning, the 36-hour period had lapsed last Monday at 7 p.m.
Okay.
And that is why we were initially notified that there would be inquest proceedings at the DOJ at around 3 or 4. And we were there, but no CIDG personnel were to be found. Monday.
Okay. Before it lapsed at 7 p.m.
Yes.
So hindi po napunta yung CIDG?
Hindi po. Okay. We were there. I was there. I had gone ahead at DOJ. They were already constituting a panel. I had talked to Senior State Prosecutor Dong Fadulion, and they were already constituting the panel, but then they had received word almost at the last minute.
So what is the excuse of the CIDG? They were supposed to be there, sir.
They did not proffer any excuse. That is why I told the media who were there waiting that, well, this means that the 36-hour period had lapsed and that the CIDG would be liable under Article 125 of the revised penal code.
So if it lapsed, what does that leave? What can your client do? What can you do for your client, rather, if it lapsed? Kung hindi natuloy yung 36-hour deadline, sir?
Well, the one thing we could do was, of course, to demand from the CIDG that they be released immediately, because at the lapse of the 36-hour period, there would be no legal basis to hold them. But then they were invoking this circular by Secretary de Lima yesterday during inquest proceedings. That's why I even jokingly said, why don't we summon Secretary de Lima? She's just around the corner to shed light on what she means by this circular.
And the circular was what, sir?
The circular interpreted certain provisions of Article 125 and provided certain exceptions. But the circular itself even said that it was the exception rather than the rule, and that Article 125 should be strictly construed in favor of the accused and against the state.
In favor of the Vice Mayor and Reynaldo Jr. Basically, that's what you're saying, sir. So, naglaps po yun, and then from my understanding, your clients refused to sign a waiver of detention. Tama ho ba?
Yes, because it would have...
What does that mean?
Well,
it's a waiver of detention, and what does that mean?
A case is properly an inquestable, quote-unquote, because there's no such word, an inquestable case when a person is caught in the act of committing a crime. And therefore, the 12-18-36-hour rule applies depending on the gravity of the felony. So, therefore, the authorities have to deliver that person to a prosecutor to determine whether there is probable cause. So, you may waive the 36-hour limit and consent to a regular preliminary investigation wherein affidavits and counter-affidavits would be exchanged. Yes, but that we fear that would also be tantamount to a waiver of our rights under Article 125 and whatever consequent criminal liability may ensue against the authorities.
So that means because they refuse to sign that waiver of detention, what does that mean to them? That means that does that mean that the rights are violated in terms of...
Yes, we are insisting that their rights were violated. They should have been set free, and therefore, by the failure of the authorities to set them free, criminal liabilities have ensued.
But the inquest panel did not rule in your favor, obviously, because your client is still detained. Because there were supposed to be provisions in that revised, Article 125 of the revised penal code, that a memo written by former Secretary Laila de Lima put exceptions, which the CIDG is using.
Yes,
to keep
definitely.
All right. I was actually quite surprised, to be honest with you, why you became the lawyer of the Parojinogs. Why? Because you're known to be an anti-crime crusader. Normally, sir, you would be on the well, you wouldn't be dun sa side ng mga Pangulong.
Yes, definitely.
What happened? Why are you representing them?
Well, because first and foremost, I'm a lawyer, and it is my sworn duty to protect the rights of people. And as Justice William Douglas of the U.S. Supreme Court once said, the liberties of none are safe unless the liberties of all are protected. And the rights of people, whether they are hated or loved, are the same under the law.
What makes you want to defend them, though? Are you close friends? Have you known them since before, sir?
I've known Vice Mayor Paruhinog through Herbert Colango, one of the witnesses against Senator De Lima. In fact, she was one of those who had prodded Colango when he was waffling about whether to go public with what he knows about De Lima to finally take the plunge and testify against the secretary.
So ano ba talaga ang relationship ni Vice Mayor Nova and Herbert Colango, sir?
I think they're sweethearts.
Okay. So they're boyfriend-girlfriends,
Yes.
they're partners.
Yes, they
That's
are.
ano na yun, that's out in the open.
Yes, definitely. And I will not deny that. And I will not deny the link, of course.
So, Sunday morning Sunday pre-dawn raid. Are you even questioning the search warrants? Let's start with that. Balikan po natin yung Sunday pre-dawn raid.
Yes, we will go through every step because there are also stringent standards with respect to the issuance of a search warrant. Because a search warrant is the exception. Going into a person's house, the authorities going to a person's house is the exception rather than the rule in a constitutional democracy. As they say, when they were doing the Magna Carta, a peasant's house may be so ramshackle that the wind comes in, the rain comes in when it storms, the sunlight comes in, but the king and all his men cannot come in.
So, in other words, sir, what is the problem with the search warrant?
Well, we will just check whether the people who applied for the search warrant really had personal knowledge. Secondly,
That there are firearms.
yes, because every search warrant must be based on personal knowledge, not hearsay, and not conjecture, not suspicion.
Right.
Secondly, a search warrant, as a general rule, has to be served in the morning, in daytime, at reasonable hours. Yes, the Chief PNP is right, it may be served at any time, but then, if it is served at nighttime, then the reasons, therefore, must be stated in the warrant itself. And the reasons acceptable, the only reasons acceptable to the law is that there is a statement to the effect that the things to be searched and seized may be found in that place only at night, or it is in the possession it is in the person of a citizen that goes there only at night, or it is in a motor vehicle that may be found there only at night.
So, attorney, ibig sabihin po nun, pwede lang kayong mag-search kung yung hinahanap nyo nandun lang kapag gabi.
Yes, and there is personal testimony. Miss magsasabi nun sa korte, gabi lang po naririyan yung taong yan, na may dalang shabu, gabi lang po matatagpuan yung firearms, gabi lang matatagpuan yung tao dyan.
Sa lahat mo ng kaso, sir, that you have defended at inyong yung you lawyered for or against, nasusunod ho ba talaga yan? Yung ganun?
Well, pag hindi po sinunod, then there is something wrong with the warrant. And therefore, that is a ground for quashal or invalidation of the warrant. And if the warrant is invalidated, then under the doctrine of fruit of the poison tree,
Right.
then all evidence seized by virtue of that warrant becomes inadmissible as
Then
evidence.
let me go back to this, sir. The case of former Albuera mayor who died, sir. It was also a pre-dawn raid sa kulungan po niya.
Yes.
So, ang sinasabi niyo po, kailangan yung mahahanap nandun lang kapag gabi. Eh, di ba, nahanapan po siya ng baril at drugs? Eh, nakakulong ho siya eh. That means
Yes.
at any given time, hindi lang ho nandun yung drugs at yung baril nung gabi. So, they shouldn't have searched him that pre-dawn raid, sir.
Well, actually, I'm not involved in that case in any way, but if I may just say so, and I'm being consistent in this because I've called them out on this. They did not have secured that warrant because the Albuera mayor was in a detention facility, which is not considered a domicile or a residence under the law. He may be searched anytime. And things may be seized there at any time with or without a
Right.
warrant. A warrant is a superfluity there.
All right, we're still gonna have a lot of things to discuss on this case. This is the source on CNN Philippines. Still to come. What's
Ang papa ko, di naman marunong magpaputok ng baril yan.
Kasi yung ibang mga kasamahan niya, patay na. Siya na lang. Siyempre, nagtago siya doon sa may tricycle. Nakita siya nung bumaril, nung pulis, sabi niya, sir, huwag mo akong patayin. Binaril pa rin siya.
Attorney, but the police is saying it's a legitimate operation. The police is saying nanlaban.
Of course.
The police is saying the mayor had an army, sir.
Their security detail has been pulled out also. So we do not see where the army would come from. At any rate,